Good afternoon, everyone. I hope you're doing well so far. Just want to check if everybody can hear me. Okay, great. Okay, so before we start, I would like to thank everybody for joining us today. My name is Jacqueline Mercurio. I'm the Director of Sales for No Borders Law Group. So I'll be your host for today's webinar. So on behalf of No Borders Law Group, which is the parent company of No Borders Migration Law, we're pleased to have you with us. And we understand that receiving a visa refusal can be stressful and overwhelming. And today's webinar is designed to help you better understand what a visa refusal means. And later today, our speaker will talk to you more about in details. So before we begin, just to cover the few housekeeping rules. So we have a 60-minute session. It's 12:03 p.m. right now. And then that will be including a Q&A session at the end of the session. So if you do have some questions, I would like to encourage you to use the Q&A chat box to provide some questions, and we will try to give you the answers as soon as possible. So basically, this webinar is just a general information. So we're not giving you any legal advice as of the moment. So if you have any private questions that you want to ask in terms of your circumstances, just feel free to reach out to us. I'll be reaching out to you at the end of the session as well. We will be also having a QR code at the end of the session where you can be able to book a free consultation with one of our senior lawyers. So before I introduce you with our lawyers gonna do the webinar for today, DJ, could you please move the slide, please? Okay. So I just want to talk to you more about of who we are. So No Borders Law Group. So we started the company. We incorporated back in 2022. But in terms of migration, we help thousands of people, and we've even done 27,000 applications or more by now since 1998. So we are a very experienced migration um, law firm. So majority of our team is composed of principal lawyers, senior lawyers, and experienced migration lawyers who can be able to help you in terms of your circumstances. So without a further ado, I'll just introduce you with Joshua Lian, who's going to be our speaker for today. Okay, thank you very much for that. Okay, so key discussions for today. I know everybody's excited to talk about, the visa refusals and how do we go about it. But just want to give you some overview of what we're going to talk about today. The first thing is the shift to on the papers review. Next one is why your written submission matters. What are the common mistakes to avoid? We will be giving you a practical example in relation to some circumstances and how we can be able to help you. So without any further ado, I just want to introduce Joshua Lian, who's going to take over this presentation. Over to you, Joshua.
Thank you, Jack. Hi everyone. Thanks for joining the webinar. So as you know, my name is Joshua and I'll be the speaker for today. So, all right, let me take control. Okay. All right, next slide. All right. So, as you know, at the Administrative Review Tribunal, where you've received a visa refusal, it is important to understand that certain migration decisions now can be held without an oral hearing, and especially for many applicants that are looking to challenge a temporary visa refusal, there might no longer be a chance to explain your circumstances in person. So what this means is that the outcome may depend largely on the written evidence and submission before the tribunal, whereas in the past, you might be given the chance to present it in person, orally before a member. Now it looks increasingly the tribunal is implementing a on the papers review. So oral submissions for student visas, for example, is being phased out, and going forward, it is mainly going to be decided via written evidence and submission. Okay. Now, so on the papers, what that means, as I mentioned earlier, applicants could attend hearings in the past and present their case to a tribunal member, so they could clarify concerns and answer questions in person. But now, um, the shift to on the papers assessment means that the ART may assess department's decision purely based on the documents and submissions. So that means no oral hearings at all. So now, where the tribunal needs more information from the applicant, they may issue a written request. So these written requests come with a very strict deadline for response. So if you fail to respond in time, it can significantly affect the outcome of a review, and there is often no second chance. So as some of you might know, generally speaking, there's 28 days from when you receive a refusal to respond to that by submitting an application to the ART. So that is quite a strict time frame. There is really no options to request an extension. So if you don't lodge your ART submission within that 28 days, you might miss the deadline altogether. So now, because of the shift away from oral hearings, your written submission, is more important than ever, because you don't get a chance to speak to the member. So your only opportunity to present your case becomes the written submission. It is the main way to present your case. And if the submission is not prepared correctly or doesn't address the key points, it could fail altogether. So it's very important now that the written submissions are prepared professionally. So when we are responding to a decision to refuse, we need to address every refusal ground that was provided in the decision record. So every reason needs to be carefully examined and answered, and you're going to provide the relevant facts and supporting documents that are pertinent to the reasons why the case officer might have refused the application. So if you ignore or only respond to some of the grounds of refusal, then it will weaken the entire application. So it's important to go through it reason by reason and ground by ground and explain why you are able to address and provide a reason why they should not have come to that conclusion. So as mentioned, you need to not just state claims, right? You can't just say, I didn't do this. You have to back it up, right? Why didn't you do this? So that could be things that you could explain to show evidence to support your claims. And these evidence can come in the form of financial records, employment documents for student visa refusal, for example, academic records, and things like that. So all documentary evidence that we can use to support your case should be provided when preparing a claim to refute the grounds that the case officer has made. Now, as mentioned, a story just isn't enough just by narrating what happened and claiming that, yep, this happened and I said this or I didn't say this is not enough. You can't just assert what happened. You have to back that up with facts. So you have to link your assertions with well-prepared submission and evidence that refutes the decision that was made. So this is very important that you connect the facts to the law and not just make statements. You have to always link it back to the law. All right, so that's a key point and something that we can provide obviously as professionals in the legal industry, that we will understand the nuances involved and how can we link the evidence to the issues. So there are a few common mistakes that harms a review. A lot of applicants understandably will get emotional when they receive a refusal, and they might be tempted to respond emotionally. Now, that is often an obstacle because the department looks at cases on a factual basis. So if you are going to argue from a point of emotion, that would rarely, change the outcomes. You need to always back up your evidence with, back up your claims with evidence, cold hard facts, as they say. So that's one point. Relying on emotion itself is not a good point, not a good um, argument. So moving on, generic templates. So one might be tempted to go online, do their own search and say, "Oh, well, this is a good template I could use. Someone has succeeded before using this template." That is also a very common mistake that one might make, because look, every refusal, even if it might sound the same in the decision record, is different because everyone's circumstances is different. And so if you just provide a generic submission, you can often miss the department's specific concern with your case. So again, it's important to go through the decision record point by point and make sure you don't miss any reasons why the case officer might have refused your application. So generic templates, although might simplify things, is often not sufficient in putting forward a strong case. And finally, we can come to another common mistake, which is ignoring inconsistencies. So sometimes with a long immigration history in Australia, you have a lot of facts they've provided to the department in the past. Now, if sometimes when you provide your submission, you forget or you misstate a date, it could show up as inconsistencies. If you put the wrong date of when you started your studies, or a wrong date on when you got together in a relationship with your partner, all of these things will be scrutinized by the member. So it is important that any inconsistencies in your explanation, in your submission, is addressed and make sure it is something that is put in place, because sometimes it's the minute details that could ruin the entire submission. So it is important that all inconsistencies are addressed and not ignored. And it should be explained, directly, and as always, backed up with evidence. Right, so just to give you some practical examples of our experience at No Borders. So we had this one case. Obviously, I can't go into specific details, but we had this Polish student who had his student visa refused. All right, so the department questioned whether he was a genuine student, whether he intended to stay in Australia temporarily, and well, during the review, we had to prepare comprehensive submissions to support his case. So essentially, they were concerned with his study history. Why did he study something at a higher level? And then when he came to Australia, he reduced the study level. So, for example, going from a bachelor's to a diploma. So, all of these things are factors that the case officer took into consideration, and so they were concerned that he was not a genuine student because he dropped his study level, he studied a different field, and we had to make sure that we address the case officer's concern. So that includes, like I mentioned, his study pathway, what his career objectives were, and his employment prospects, as well as his ties to his home country. So we had to go point by point and explain, that it made sense for the student to study this degree because of what he hopes now to achieve. So we had to tie that in with his current circumstances. So we showed evidence of his job experience, his goals in getting a job offer letter from his home country, things like that. So it's not just to assert that he has these goals or these career objectives, but also to prove via documentary evidence that there are these things um, that exist in reality, and not just him asserting these claims. So we prove it by um, offer letters, by tax records, things like that. So ultimately, once we prepared the comprehensive submission and we submitted it to the department, the tribunal, they decided that on the papers, it looks like everything made sense. Everything was basically convincing, that they could see from the evidentiary documents we provided to support his claims and submission that he was indeed satisfy the genuine temporary entry requirement, and so they remitted that application back to the department. And so it shows how it is important that we carefully prepare cases that is submitted with credible evidence. Because if we just merely stated that he had these career goals and he wanted to, pursue his career back in Poland, that wouldn't be enough to convince the member that there's actually substance behind his claims. So once we provided documents to support that, it made the evidence even more convincing, even without an oral hearing, because we anticipated the concerns that the member might have, and then we provided the documents to support that. So this other case involves a employer-sponsored visa. So this is the regional employer-sponsored visa, and this client approached us after his visa application was refused. So in this case, the department actually questioned whether he was able to satisfy the requirement where um, prospective applicants showed 3 years of skilled employment. Now, the department relied heavily on concerns about the financial position of the previous employer, and not so much so the applicant's actual work history. So as you can see, the department made that decision. So when the client came to us, he was concerned, obviously a little bit confused, and we made sure to explain the process to him, made sure to explain what we could argue, what points we could make. So once we understood his background and circumstances, we began the thorough process of collecting all his documents, and making the case that it is in fact not relevant that the department considered the employer's financial circumstances, when in fact the applicant can prove through his pay slips, through his prior skill assessment application, which was considered a third-party verification of his experience, that he has actually the documents to prove that he worked at this company, at this business. And so even though the employer had financial issues, that is separate to the visa applicant's work history. So we had to prepare a comprehensive submission to explain the argument that the case officer made a mistake in focusing on the employer's financial situation, but rather we should be focusing on the applicant's employment history. So once we were able to make that case and support our submissions with the evidence to show that he has the 3 years work experience as he claimed in his application, we were able to successfully convince the member, and so the case was remitted back to the department and gave him the opportunity to secure their 494 visa. So these are just two examples of the many ART cases that we've handled in the past. But the common thread here is that ART cases can be complicated due to the fact that we are having to submit and refute the decision that was made by the department. So if at any point we missed a detail, we forgot to address something, it will be picked up on, and these cases might not have been successful. So it's important that we showed all of these things, and includes things like evidence of the career progression, as per the first case, the student visa case. It showed the link to the qualifications. It showed that there was correspondence from the employer confirming that future opportunities, and as well his plans that support his goal to return to his home country. So all of these things were the stuff that we provided in the application. And because, as I said, we anticipated what the member might bring up, we were able to cover all these grounds without missing anything, so that it was a full and comprehensive application. So submission in itself, obviously very important, but another key thing to note is that there are time limits for these kind of applications, right? So time limits to review are strict and often quite short. So we understand at No Borders that life can be busy, and you are busy with your day job, with your study, and sometimes you might miss a date. So when you engage us to assist with your review applications, we were able to keep track of the key dates. So this way, it would take a burden off of you, and you don't have to have, back of mind worrying if you've missed a time, worrying if you've missed a timeline and a key date to respond. So if you come to us quickly after refusal, it allows us more time to plan your case, to come up with arguments to strengthen your case, and to give you the chance to build the strongest possible case. Okay, so we can analyze the refusal decision in detail. If you come to us early enough, then we can identify if there's any evidentiary gaps, any risks that you might need to be aware of, any things that we need to strengthen. So we will help you to prepare a detailed and evidence-led submission. And finally, as I said, each case is different. So we'll address each case on a case-by-case basis. We don't use templates just as a generic template for everything. We will read through the decision record and make sure that every salient point has been addressed. So we will analyze, we will identify, prepare, and finally submit a strong application for you, because we have had, as mentioned at the start, very extensive experience handling these kinds of matters. So if you come to us after refusal, we'll be more than able to assist you with the ART. All right, so I guess I've zoomed past this webinar. I guess I can open the floor to Q&A.
Okay, thank you very much, Joshua, for that insightful presentation. Um, okay, so we received one question, which is a very interesting topic. So visa refuse, this is from Maucho. Visa refused last week. Main reason for refusal was financial capacity or show money because the department believed my bank statement is not genuine. Can I submit new bank statement for my case?
Okay, so main reason for refusal,
I
financial
guess
capacity.
I guess, Maucho, this is a very specific answer, questions in relation to your circumstances. I would encourage you to book a consultation, and we're happy to address this matter, and we can be able to provide you with some legal advice and how do we go about it.
Yeah.
Okay.
Yeah, because yep. Let's see.
Okay.
Um,
So I'll come back to you, Maucho. So I'm gonna look at the next question. I already lodged my appeal with a migration agent a few months ago, but
Oh,
planning to transfer my case to a migration lawyer instead. Would that be okay? Or it will affect my application? Joshua?
right. So, hi, Winona. So just to address your concerns, no, that's fine. No worries. We can definitely transfer your case to a migration lawyer. It would not affect your application. Yeah, all we need to do is to review your case in detail. So we'll ask for documents, everything that you submitted in the application. Yeah, so to keep it short, no concerns at all. If you're looking to transfer from an agent to a lawyer, it would have no effect on your application.
Okay, thank you. Any more questions? So if you do have some questions, you can turn on your mic and feel free to ask that question to Joshua.
Oh, I think
Yep,
someone,
Amber?
okay, should we just maybe just type it out? Yeah.
Okay.
I'm not sure if we can like, no worries. Yeah, I'm not sure if we can unmute her, but maybe if
You
you
can,
would like,
yeah,
yeah, just type out your question.
Amber, you can try to unmute your mic. Okay.
Oh, okay.
All right. So the question from Amber is, just give me a second.
Ah,
Okay.
okay.
Yeah.
I
Over to
see.
you, Joshua. Yeah.
Yep, yep. So look, obviously, I was thinking of addressing this in the webinar. But see, the issue with AI is that it can sound very convincing, you know, and as I mentioned earlier, you can provide your facts, feed the chatbot with your details, but at the end of the day, it is still not a lawyer, right? It is still not someone who has trained in immigration law. So personally, I admit I have used AI as well when I assist with, you know, when I'm going through documents just to see, and it is still full of mistakes. So they will, I'm not sure if you've heard of this, but they can hallucinate, they can make up regulations that don't exist. So it just becomes double the work. So now not only do you have to check whether it is right, you have to now go in and do the research yourself. So my short answer to that is the risk is, look, you are here in Australia or applying for a visa in Australia that costs money, a substantial amount of money. And if you're going to refer to a chatbot for your future and they made a mistake, um, look, I just don't feel like it is worth all that time and effort that you've invested in yourself. It's a good tool to give you some ideas, you know, where to start, but to rely on it to prepare your entire submission, I just think it's too risky and it's really not worth it. Um, so look, I would say the legal risk, there's not so much of a legal risk, you can use it, but it's more the issue with actually getting the outcome that you want. So if you don't know the questions to ask, it won't be able to respond, right? It won't be able to respond in a way that means anything to you. So I guess that's my short answer. At the end of the day, you still need an expert to make sure the information you're getting is true or not true, or outdated or, you know, relevant.
Yeah, I think to add on to that, migration lawyers actually looking at the policy, the legislation, and the regulation from the migration industry, and this is something not available in public. What you can see actually on the public information is just a high level of overview. But once you actually engage with the migration lawyers, this is something that they have to understand your circumstances and tailor the approach that we gonna do in terms of the written submission. In that way, we can get a best possible outcome in relation to your concern. So understand, Masho, that you have a questions a while ago relating to your, the bank information due to financial issues and stuff. I would highly recommend to book a consultation with us, and then we can have a look at all the documents that you've got, and then we can be able to provide a legal advice on how we can move forward. So let me just check if there's somebody else. Okay. Any more question? Okay. So how to contact you for appointment? EJ, can you be able to share the QR code whereby Masho can be able to contact us for appointment?
Yes,
Do
hello.
we
I
have a
think it
QR
should be
code?
on the screen now.
Um, we can't see it.
PowerPoint slide.
I think it's showing on the screen now,
Yeah.
Jack.
Okay. Okay. So that's the I can't be able to see it, but that's absolutely fine. Just give me a second. Let me see what's happening. Um, okay, so you can be able to scan the QR code. So if you want to book an appointment with us, you can book a free 20-minute consultation. So one of our team member can be able to call you even within the day, and then from there we will be happy to arrange a one-on-one meeting with one of the lawyers. So we can be also we will be also sharing the QR code for your reference, and I think we have all the emails that you've got in there. We're happy to give you some information of what we have talked about it today. And then we also have a contact number that you may call us. If you can type it in, EJ, so at least they can be able to ring us and provide, you know, if you can provide a phone number so they can reach us out as well, that would be great. So is there any more question? We still have like 26 minutes. To run through this webinar. Okay,
Okay.
so feel free to contact us. So I guess you can be able to see the link that has been provided with one of our team members. You can call us to 1300 066 267. Um, if we don't have any questions for today, I guess we can end the webinar. But I would like to thank you all for attending this webinar. Hopefully, we can be able to assist you with any visa matters or any refusal matters. And yeah, have a great day. Thank you, Joshua.
Okay. No
Thanks,
worries. Thanks,
everyone.
Jack.
Okay, bye.
Thanks, everyone. Thank you.